I get so many questions surrounding whether or not someone can sue the police. Today we're going to talk about that. This is Christina Williams with Just Criminal Law.
And David Mann, legal storytelling specialist. Okay, so this sounds like there's lots of stories surrounding this. So someone wants to sue the police. So that sounds like it's going to be very difficult. Can you explain?
It is very difficult, and it's very unlikely that they'll be successful because of this doctrine that the Supreme Court created called qualified immunity. And that was over 40 years ago. And it makes it so difficult for the average citizen to successfully sue the police.
But I bet, as you sort of indicated, many people think they can sue the police because something happened with the police that didn't go well, and now they think, oh, well, now what we do is sue. So do you have a story of how that may have turned out?
Sure. So I have a case where I thought what happened was really unfair, and it really bothered me. But, even in spite of my personal feeling about it, I knew that to fight it would be an uphill battle. So what happened was my client, who was on probation, was asked to pick up a friend at a local bar. So he went to the bar, and instead of waiting inside of his car for the person to come out, he went inside to find the person. Now, this was a violation of his probation. It just so happened that one of the police officers who kind of had a bone to pick with him, they knew each other outside of this situation, kind of in a personal sense, not necessarily a professional sense. And so the officer recognized my client, he's on probation and he shouldn't be here. So the two made eye contact, and my client started to exit the bar, went out the side door, and the officer went out the front door, met him in the parking lot, and immediately confronted him and escalated the situation because he really didn't like my client.
So it sounds like at that point, even though it's a police officer and someone in a bar under probation, it's almost now become sort of two guys in a parking lot. And that's probably what it felt like to your client. And so what happens then?
Well, exactly. That's exactly what it felt like to him. And the officer, turned the confrontation physical and ended up, wrestling the client to the ground, putting his head in the gravel, and he had his arm behind his back. It was hurting him. It was painful. And so my client was struggling to try to release some of the pressure and to get his head out of the gravel. Well, in the process of that, the officer's body camera on his glasses was knocked off. So my client was ultimately now in trouble for destruction of property, and the officer charged him with interference, although that's questionable because he was just trying to release the pressure on his shoulder. The officer says that during the physical confrontation that his knee got hurt when he had to wrestle the client to the ground, and that the client caused this, so they charged him with an aggravated assault felony. And the whole reason for the initial contact was just a probation violation. So my client ends up being arrested, which now gets us into this idea of suing the police. Was that arrest lawful? So had the client just been in the bar on probation, the officer, that's not an offense that the officer can arrest him for. But instead of, just talking to him about it and saying, hey, I know you're on probation, you shouldn't be here, you need to go home, and I'm gonna let the prosecutor know that you were here, and then the prosecutor can potentially revoke his probation, he escalated the situation. So all of a sudden, because the officer, wanted to turn this verbal exchange into a physical confrontation, My client's now facing felony charges and has been arrested, and it really didn't need to go that way.
And you're saying that in your experience, when someone has decided, well, you know what, I was really wronged here and I'm going to fight back and I'm going to sue the police officer, that this is now protected by this Supreme Court ruling?
Right, so the officer, as long as he's doing what is considered legal, it's really difficult to sue him or his agency in a civil matter. And so, as far as the contact and what happened here, all the officer would have to show is that he was acting in good faith. Now, I believe there's definitely two sides to this story, and I believe he was not acting in good faith. But, then there were 3 or 4 other officers that were with him, and, they're all going to stick together for the most part and support what happened. And then you have my client who, it's like 1 against 3 or 4. Interestingly enough, what was happening, everyone thought was egregious enough that they had their cell phones out and, they were recording the interaction. And a lot of people were really angry about how the officer handled the situation. Now, ultimately, we were able to negotiate a very good resolution where, my client was at risk of going to prison because he was on probation and violating that probation. But we were able to get the charges dismissed, and he admitted to the probation violation, and he had to start his probation over, but he didn't have to go to prison. Now, he didn't, in light of this, that was good enough for him. He knew there was an uphill battle if we wanted to sue the police, and he really just wanted to get on with his life and move past this situation. And so, we did that. We got him an outcome he could live with. But, this was really unfair in my opinion.
Yeah, it sounds like it really was. And so it sounds like also that he could have been not only not successful in a lawsuit against the officer, he could have been in much, much hotter water and a worse situation had he not reached out to you. So it seems like that could be a good idea to do that. And how might someone do that?
We'll include a link in the description where they can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.